Welcome to this explainer. Right, let's dive straight in. Today, we're unpacking a massive, high-stakes legal clash that literally shook the foundations of the South African justice system. We're looking at this really fascinating tension. So on one side, you've got a massive financial institution's legal right to collect on an unpaid debt. Fair enough, right? But on the other side, you have a citizen's absolute, fundamental, constitutional right to keep a roof over their head. So how exactly does the law balance a bank's bottom line with a human being's home? It's like a giant puzzle. We're going to walk through a landmark constitutional court document from 2006 that perfectly captures this whole struggle.
It all starts with this one simple yet incredibly powerful sentence. Everyone has the right to have access to adequate housing. That's Section 26, subsection 1 of the South African Constitution. Now, on its face, sounds like a pretty standard, broad human rights declaration, but when the ink actually dried on this Constitution, this single sentence created a literal seismic shockwave through the legal system, especially in the world of banking and debt collection.
Which brings us to the core question of this explainer, really. Can a court clerk, just an administrative clerk, take away your home without a judge ever even looking at the details of your case? Picture the scales of justice here, balancing corporate debt collection against fundamental human rights. For decades, the system heavily favored the mechanics of debt collection. If you didn't pay your mortgage, the process of losing your home could be surprisingly administrative. It mostly just happened behind the scenes.
To understand how that actually happens, we need to translate a tiny bit of legal jargon. A default judgment is a ruling granted by a court registrar. Basically, like we said, an administrative clerk, when a defendant fails to respond to a summons. Banks relied heavily on rules like Section 27A of the Supreme Court Act and Rule 31.5. Basically, the way it worked was, if a homeowner fell behind on payments and didn't formally defend themselves in court, the bank could just go straight to a registrar. The registrar would then essentially rubber stamp the judgment and issue a writ of execution to seize and sell the property, their home. And the crazy part? No judge required. None.
Okay, let's dive into this. Part 1. The housing versus debt clash. So that incredibly streamlined administrative system eventually hit a massive constitutional roadblock. The root of all this legal chaos actually stems from a landmark ruling known as the JAFTA case. The Constitutional Court looked at the magistrates' courts and basically said, wait a minute, hold on. You can't just have clerks authorizing the seizure of people's homes without any actual judicial oversight. They ruled that, because of that constitutional right to housing we just talked about, a human judge absolutely must weigh several relevant circumstances before taking someone's home. They have to look at things like how the debt was incurred, what attempts the debtor actually made to pay it back, the overall financial situation of both parties, the exact amount owed, and, whether the debtor's even employed. Real human factors.
Which brings us to Part 2, confusion in the courts.
Now, the JAFTA ruling was technically only about the lower magistrates' courts, but man, it sent a ripple effect straight up the judicial ladder. High court registrars suddenly went into full panic mode. They were thinking, well, if magistrates' clerks can't authorize home foreclosures anymore, do high court registrars still have the power to do it? You can see how the dominoes start to fall here. First, the JAFTA precedent changes the rules for the lower courts, then the panic hits the Cape High Court, where the deputy judge president actually issues an instruction completely halting registrars from granting execution orders. Just stop them cold. Meanwhile, over in the Johannesburg High Court, a registrar gets a default judgment application from a bank, feels that exact same constitutional anxiety, and just refers the whole thing to a full bench of judges to figure out. So the normal debt collection procedures for major banks practically froze while the courts scrambled to figure out what was actually legal.
Now, what's really interesting about this slide is how two completely different high courts looked at the exact same constitutional problem and came up with totally conflicting rules. I mean, polar opposites. The Cape High Court ruled that registrars absolutely do not have the power to declare property executable. Full stop. Furthermore, they said the bank's initial summons must proactively justify why taking the home doesn't violate the Constitution. But conversely, you have the Johannesburg High Court saying, actually, registrars can still execute properties, provided the bank submits an affidavit answering 5 strict criteria. Things like whether the home was bought with a state subsidy or if it's currently occupied. It was honestly a fragmented mess.
So with the high courts completely disagreeing, who breaks the tie? Enter Part 3, the Supreme Court's fix.
With the high courts deeply divided and banks just totally unsure of how to proceed, Standard Bank appealed the Cape High Court's strict ruling. They took the whole matter straight to the Supreme Court of Appeal, the SCA, to finally get some clarity on how default judgments should be handled nationally. And the SCA, they completely overruled the Cape High Court. They declared that a bank does not need to justify a constitutional limitation up front just to file a summons. In their ruling,
The SCA stated quite clearly that if a defendant believes losing their home will infringe on their rights, and here's the quote, it is incumbent on the defendant to place information supporting that claim before the court. In other words, the burden of speaking up, that's entirely on the debtor, not the bank. However, the SCDA did recognize a glaring issue. Most defaulting homeowners don't have lawyers. They might not even know they have these constitutional rights in the first place. So they created a bit of a compromise. The SCDA issued a new practice direction. From that day forward, any summons seeking to take a person's home must explicitly print a warning right there on the document. It absolutely must tell the defendant about their Section 26(1) right to adequate housing and warn them that if they want to protect that right, they have to actually come to court and prove it.
So, the crucial point is, the Supreme Court issued a fix, but not everyone was happy with it, which brings us to Part 4, the Public Interest Challenge.
Here's the major plot twist. Throughout all these appeals, the original homeowners who actually defaulted on their mortgages, they were completely missing from the courtroom. They hadn't defended themselves at all. So you might be wondering, how can an uninvolved organization suddenly step into a Supreme Court case? The answer is Section 38 standing. This is a brilliant constitutional provision in South Africa that departs from traditional common law. It basically allows anyone, including an organization like the Campus Law Clinic at the University of KwaZulu-Natal, to approach a court alleging that a right has been infringed in the public interest. The clinic used this to step in, arguing that the Supreme Court's whole compromise just didn't go nearly far enough to protect indigent, vulnerable citizens who couldn't afford legal representation.
And incredibly, the Constitutional Court actually agreed to give the clinic standing. They did this for a few really critical reasons. First, the original debtors were absent. Second, the Supreme Court's decision was now binding. It was creating this massive national precedent. And third, forcing the clinic to wait around for a brand new, separate case to pop up would just cause totally unnecessary delay. But most importantly, the court recognized the deep vulnerability of unrepresented people facing foreclosure. They needed someone to speak for them.
But did the Constitutional Court actually agree with the clinic's attempt to overhaul the rules? Let's look at Part 5, Right Fight, Wrong Time.
So the Campus Law Clinic finally had their foot in the door of the highest court in the land. The tension here was absolutely at its peak. The clinic wanted the Constitutional Court to completely overhaul the debt collection rules, entirely strike down the laws allowing registrars to grant default judgments, the whole shebang. But in a wildly surprising outcome to many, the verdict was a dismissal. The Constitutional Court dismissed the applications. They literally threw the case out without actually ruling on the core housing issue at all. No way, right?
And this brilliantly illustrates how the highest levels of law actually operate. The court stated, the desirability of avoiding a piecemeal determination of issues is important. Now, what does that actually mean in plain English? Well, the clinic was trying to challenge the constitutionality of massive systemic rules, Rule 31 and Section 27A. But those specific rules hadn't even been fully debated in the lower courts during this particular case. Furthermore, if you're going to completely rewrite national court rules that impact the entire economy, you can't just do it in a fragmented way. The court pointed out, look, the Minister of Justice wasn't even involved in the earlier appeals, nor were the other major lending institutions or housing bodies. You absolutely need everyone at the table for a fair fight.
Which leaves us with this final thought to ponder. If justice requires the right answer, doesn't it also require the right procedure? This Constitutional Court decision, as frustrating as it might seem, wasn't actually a defeat for housing rights. It was a really powerful lesson in legal fairness and structure. The court left the door wide open for the clinic, or anyone else for that matter, to challenge these debt collection laws again, provided, of course, they start at the High Court, join the Minister of Justice, bring in the other banks, and build a complete, proper record. It reminds us that protecting constitutional rights isn't just about bold declarations. It's about the painstaking, highly structured procedural work required to change the system fairly. Thanks so much for joining me on this explainer. I hope this deep dive into the mechanics of justice has given you a whole new perspective on how our rights and our systems interact.